A federal judge in New York has ruled that the NSA spying program and bulk data collection is legal. Legal. Shocking. So this obviously contradicts the previous ruling in the Larry Klayman case, where Judge Leon said it is clearly unconstitutional under the Fourth Amendment. So I guess you could call it good news, is that neither one of these cases supersedes each other, so the one that happened today doesn't override the previous one. So this just means that there's a conflict, and it needs to be appealed, and it needs to go up the chain, and it's looking likely that it will end up in the Supreme Court. Whether or not that's a good thing or a bad thing right now is yet to be seen. I mean, the court leans in a conservative direction, that's for sure. But you never know. Every once in a while, I don't know, Justice Scalia or Alito or somebody will throw a curveball and say, I'm actually going to be old school conservative and say I believe in small government, which means the government can't spy on everybody. So I would say I couldn't even venture to make a prediction as to if it goes to the Supreme Court, which way they'll rule. I know which way they should rule, but I don't know which way they will rule if it gets there. So U.S. District Judge William Pauley was the guy who made this decision, and he said in a written opinion that the program, quote, represents the government's counterpunch to eliminate al-Qaeda terror networks. The government learned from its mistake and adapted to confront a new enemy, a terror network capable of orchestrating attacks across the world. It launched a number of countermeasures, including a bulk telephone metadata collection program, a wide net that could find and isolate contacts among suspected terrorists in an ocean of seemingly disconnected data. So allow me to be blunt in responding to Judge Pauley here. You're wrong. You're just simply wrong. Now, why do I say that? There's three main reasons why I say that. Number one, there is literally no evidence that this program prevented a single terrorist attack. That was the whole big newsworthy portion of the Larry Klayman case, because the government was given the opportunity, okay, go ahead, present your case. How many terrorism cases have you stopped? Crickets. Nothing. So what they do is they use it theoretically. Like, oh no, we can maybe eventually kind of stop terrorist attacks. Not we did, and I can give you the evidence. The second reason is the program led to the NSA officials spying on international sex phone calls of our troops, of all people, snooping into their ex-boyfriends and girlfriends' private lives. They were looking at World of Warcraft, the video game, spying on people there. They were accidentally looking at the wrong people with generic names. If they needed to look at a John Smith or something like that for a certain case, there would be like thousands of John Smiths that come up, and they would go through all of them. I mean, in so many different ways, this is unconstitutional, which leads me to my third point. It is plainly unconstitutional. You have to understand the whole purpose of having a constitution is to say that things X, Y, and Z are off the table, non-negotiable, not open to democratic opinion, not open to a president overriding it or some authoritarian force. These things are grandfathered in as rights. They cannot be taken away from you under any circumstances. So, want me to get more specific here? I'll be very happy to do that. The Fourth Amendment to the U.S. Constitution says, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing, key word, the place to be searched and the persons or things to be seized. Now, I was talking about this earlier on Twitter. It's like mind-boggling that the founders worded the Fourth Amendment the way they did. It's eerie because it's almost like they knew that at some far-off date in the future there would be this thing called the NSA, which would try to collect all of your, electronic information, which there's no way they could have known this stuff. And it's worded in such a way as if to suggest, don't do that. Don't do that. You need specific warrants, and you can't do an unreasonable search and seizure. So in other words, collecting everybody's metadata as part of this broad, undefined terrorism investigation, but you haven't given a reason why Grandma Dorothy or Dave the janitor down the street should be part of a terror investigation. They've never done anything even somewhat sketchy in their entire lives. And you're saying, no, we need all of your text messages, your emails, your phone calls. Everything needs to be stored because you're just part of the investigation. Well, you can't just say that and make that the case. It's not true that person should be part of the investigation. And you don't have a specific warrant. You have a broad warrant when the Constitution says you need a specific warrant. And it needs to describe the people or places to be searched. It's such an obvious violation that it's mind-numbingly stupid that this judge today in New York, Judge William Pauley, didn't do it. I'm starting to think William Pauley didn't read the Fourth Amendment.